To today's lecture on exclusion clauses. This is a high-yield topic, you must master it. An exclusion clause is a term that excludes, limits, or qualifies one party's liability for breach of contract, negligence, or certain events. It benefits only one party. At common law, the party trying to rely on the clause must prove two things. First, that the clause was properly incorporated into the contract. Second, that on a strict interpretation, it actually covers the breach that occurred. After that, we apply statutory controls, mainly the Unfair Contract Terms Act 1977 for business contracts and the Consumer Rights Act 2015 for consumer contracts. We will go through the material in this order: incorporation, construction, UCTA 1977, and then the Consumer Rights Act 2015. Pay close attention to the cases d'arcèche. They are essential for SQE application questions. Focus on the three hurdles: incorporation, construction, and statutory rules.
What is an exclusion clause? A contractual term that excludes, qualifies, or limits the liability of a party for wrongful conduct specified in that clause. Key characteristics: it is one-sided, it benefits only one party. There are two types: full exclusion or partial limitation. At common law, it must be incorporated and covered the breach. Statutes like UCTA 1977 and CRA 2015 heavily control them and often override common law. Remember the three hurdles for every problem question. 1. Incorporation. 2. Construction. 3. Statutory rules, UCTA CRA. Focus on these and memorize key cases and tests. Spend about 45 seconds on this slide. Incorporation. Signed documents. Rule: signing binds you to all terms, even if unread. The leading case is Lestrange v. Graucob from 1934. Exceptions are rare. Misrepresentation: if there was a misleading explanation of the clause's effect, as in Curtis v. Chemical Cleaning. Non est factum: a fundamental mistake about the nature of the document. Very rare. Electronic signatures are valid under the Electronic Communications Act 2000. Signed documents, you are bound even if unread. Main case Lestrange. Exceptions: misrepresentation or rare fundamental mistake. Electronic signatures are fine. About 1 minute. Incorporation. Unsigned documents. Core. Rule: reasonable notice must be given before contract formation. Key cases: Parker v. Southeastern Railway 1877. A ticket saying "Seaback" was reasonable notice. Thornton v. Shoe Lane. Parking 1971. Onerous clauses need prominent red hand notice. Interphoto v. Stiletto 1988. Onerous terms require special notice. This is now a general principle. Ollie v. Marlborough Court 1949. Notice after the contract is formed is too late. Unsigned documents require reasonable pre-contract notice. Onerous terms need stronger notice under the red hand rule. Notice after contract formation is useless. Key cases: Parker, Thornton, Interphoto, Ollie. Construction of exclusion clauses. Even if incorporated, courts interpret exclusion clauses strictly against the party relying on them. 3 key rules. First, contra proferentem. Ambiguity is interpreted against the party relying on the clause. See Andrews v. Singer. Second, repugnancy. Rule: the clause cannot contradict the main purpose of the contract. Third, four corners rule. The clause only applies if the party is acting within the agreed scope of the contract. Courts interpret strictly against the relying party. Contra proferentem means against the drafter. Repugnancy means it cannot destroy the main purpose. Four corners means it only protects agreed performance. UCTA 1977 Key Provisions. The Unfair Contract Terms Act 1977 controls business liability. Section 2. Negligence void for death or personal injury. Other negligence only if reasonable. Section 3. Standard terms cannot restrict liability for own breach unless reasonable. Sections 6 and 7. Sale of goods cannot exclude title. Other implied terms only reasonable in B2B contracts. Schedule 2. Reasonableness test considers bargaining power, inducement, knowledge of the term, insurance, and custom. UCTA controls business liability. Section 2 makes death or personal injury from negligence void. Reasonableness test in Schedule 2. Burden on the party relying on the clause, key for B2B contracts. Consumer Rights Act 2015. The Consumer Rights Act 2015 provides stronger consumer protection. Unfairness test. A term is unfair if, contrary to good faith, it causes a significant imbalance in the party's rights and obligations to the detriment of the consumer. Gray list. Terms likely to be unfair include excluding liability for death or injury, disproportionate penalties, and terms the consumer had no real opportunity to become acquainted with. Core terms: price and subject matter are exempt only if transparent and prominent. Effect: an unfair term is not binding on the consumer, but the rest of the contract remains. CRA 2015, Stronger Consumer Protection. Unfairness equals good faith plus significant imbalance. Gray list examples: core terms exempt if clear, unfair term is removed but contract otherwise stands. Key cases to know: memorize these 4 cases and their principles. George Mitchell v. Finney Lock Seeds. 1983, limitation clause failed the reasonableness test because the seller normally negotiated settlements. Hollier v. Rambler Motors. 1972, fire damage clause interpreted narrowly and did not cover negligence classic contra proferentum. Thornton v. Shoe Lane. Parking. 1971, onerous terms need prominent red hand notice before the contract. Interphoto v. Stiletto. 1988, onerous terms require special notice, the principle applies generally. Memorize these 4 cases and their principles. George Mitchell shows reasonableness in practice. Hollier shows narrow interpretation. Thornton and Interphoto show notice requirements for harsh term S. Practical rules: do and don't. Use clear, plain language. Give prominent notice for onerous terms before the contract is formed. In B2B contracts, keep evidence for reasonableness, insurance cover, bargaining power. Never exclude liability for fraud or death or personal injury. Do not use post-contract notices. Avoid clauses that contradict the main purpose of the contract. Practical advice: use clear language and proper notice. Keep records for reasonableness in B2B. Never exclude fraud or death injury. Post-contract notice is useless. Avoid repugnant clauses. Must know summary 1. 3 hurdles: incorporation, construction, USTA, or CRA. 2. Signed equals signed, bound even if unread, Lestrange. Unsigned equals signed, reasonable pre-contract notice. 3. Contra proferentum, repugnancy, 4 corners. Interpret against the relying party. 4. UCTA Section 2. Death or personal injury from negligence is void. Reasonableness test applies. 5. CRA 2015. Unfair if significant imbalance contrary to good faith. Consumers only. 6. Key cases: George Mitchell, Hollier, Thornton, Interphoto. 7. Never exclude liability for fraud or death or personal injury. Final summary: use the 3 hurdles in every question. Know the incorporation rules, construction rules, and the 2 statutes. Memorize the 4 key cases and their principles. Review and apply in problem questions. Thank you.